The most common reason for someone's Illinois driver's license to be revoked is for a DUI conviction. Any DUI conviction will trigger a license revocation, requiring a hearing to be held with the Illinois Secretary of State. Typically, but not always, a DUI conviction occurs when someone has had a previous DUI. In this case, a formal hearing is usually required. The formal hearing process can be very tricky. Obtaining the services of a qualified attorney experienced in handling Secretary of State hearings is always in your best interest. Unfortunately, many people believe they can represent themselves at the hearing and find out the hard way that it was a mistake. Simply because you have met all of the court-mandated requirements and have not been in trouble since your last case is not enough to succeed at the hearing. Knowing what to say, and just as importantly, what not to say, is crucial for success. A current alcohol evaluation will be required for the hearing. Making sure that it is consistent with your history and its contents do not minimize your past drinking is essential. The smallest mistake will trigger a denial of driving restoration. Proper preparation is the absolute key to success. Documents needed to get prepared for the hearing include a current Illinois driving record, any treatment documents, and any prior DUI evaluations. Attorney Stephen Haney will not only prepare you for your needed evaluation, but also provide you a study guide which contains the questions you will be asked at the hearing, along with the answers you need to be prepared to provide. You will basically be given the answers to the test before you take it. A formal hearing needs to be scheduled with the Secretary of State. Hearings can be done in person and are also allowed now to be done remotely. The time from beginning of the process to finally driving again is approximately 6 months. Once a hearing application is filed, the hearing will be scheduled in about 2 months. A decision will not be made the day of the hearing. The Secretary of State has up to 3 months to render a decision. Upon being granted the restoration of driving privileges, it can take about another month for all paperwork to be processed before you can drive again. Additionally, even if you are eligible for the restoration of full privileges, the Secretary of State will almost always first issue a permit that will allow you to drive for 6 days a week, up to 12 hours a day within a 200-mile radius of your home for any reason. If you only have one DUI conviction in your past, the permit will be issued for 1 year. If you have more than one DUI conviction, but less than 4 DUI convictions, the permit will be good for 5 years. Someone who has 4 or more DUI convictions will be considered lifetime revoked and not be eligible for full reinstatement, but will be eligible for a permit. Since so much is at stake, obtaining help from an attorney experienced in the license reinstatement hearing process is important. Attorney Stephen Haney has helped hundreds of people get back on the road and has been handling Secretary of State hearings for over 30 years. You are free to call him for a free review and consultation of your specific situation.